Going through a divorce? Here's what you need to know about ancillary matters in Singapore's divorce process. After the interim judgment dissolves the marriage, the second stage of the divorce process addresses something called ancillary matters. If spouses can't resolve these issues privately or through mediation, the court then steps in to make a couple of decisions. Number 1, children's issues, custody, care and control, access, as well as child maintenance. Number 2, the wife's maintenance or spousal maintenance to determine how much should be paid ongoing and going forward. Number 3, the division of matrimonial assets, how to distribute property and assets fairly. Once the interim judgment is granted, the court then schedules something called the Ancillary Matters Conference to set up timelines and to monitor the case and the process going forward. If either spouse has a lawyer, they don't need to attend these conferences personally. This structured process ensures all essential issues are resolved fairly and systematically. Wondering what happens during the ancillary matters hearing in a Singapore divorce? Here's a quick rundown. At the ancillary matters hearing, the court will, number 1, review affidavits detailing each party's assets and financial means. Number 2, allow a cross-examination of fact and expert witnesses. Number 3, evaluate evidence and the witness credibility. Number 4, consider written submissions from both lawyers, including legal references and case precedent. Based on this review, the court issues the final orders on children's arrangements, asset division, as well as spousal maintenance. The hearing may last from 1 to several days, depending on the case's complexity. Once the hearing concludes, the final judgment of divorce is then granted, officially completing the divorce process. In a divorce, what matters most when it comes to child custody? Here's what the Singapore Family Court considers. In divorce cases, the children's welfare is the top priority. Legally, a child of the marriage includes biological, adopted, as well as any children who were part of the family just before the divorce. Under the Women's Charter, children are considered anyone under 21. When deciding on custody or care and control, the court prioritizes the child's best interests, considering a couple of things. Number 1, the parents' wishes. While taken into account, these are secondary to the children's welfare. Number 2, the children's wishes. If the child is mature enough, the court may sometimes consider their own preferences. To understand the child's perspective, the family court may also conduct interviews or review reports from child experts. This approach ensures decisions are made always with the child's well-being at the center. Did you know that blocking a parent's access to their child can now have serious legal consequences? Here's what you need to know about breaching access orders in Singapore. Since the 2022 amendments to the Women's Charter in Singapore, parents who unreasonably block access now face stricter penalties. Previously, the access parent had limited options to address denied access, but now the courts have introduced additional measures. Number 1, mandatory counselling for parents involved in disputes over child access. Number 2, compensation. The courts can also order reimbursement for costs incurred, such as for missed vacations due to access denied. Number 3, additional access or fine. The courts may also grant extra access to make up for lost time or to impose fines or even imprisonment in severe cases. Number 4, suspension of access. If abuse or serious harm is involved, access may be suspended until the child is ready. These legal updates emphasize the importance of parents acting in their children's best interests and to discourage unnecessary conflict by imposing real consequences on those who breach access arrangements. Wondering who gets custody in a Singapore divorce? Here's how the court decides. In most cases, joint custody is granted, requiring both parents to make major life decisions together on issues such as education, healthcare, and the religious upbringing of the children. This approach encourages co-parenting, as even though the couple may be divorcing, they are not divorcing their child. Joint custody ensures both parents stay actively involved, promoting the child's well-being. Sole custody is only granted in rare situations where it truly serves the child's best interests. Simply having trouble getting along with the other parent isn't quite enough for sole custody. Co-parenting programs are always available to help divorced parents improve communication as well as collaboration. By prioritizing joint custody, the courts aim to support the child's stability and foster a balanced, cooperative approach to parenting. Confused about the difference between custody and care and control? Here's a quick breakdown to clarify. In legal terms, custody means having the authority to make major life decisions for your child, such as those related to education, healthcare, and religion. It doesn't mean the child lives with you. When the courts grant something called joint custody, both parents then share equal responsibility over these important decisions. Care and control, on the other hand, refers to the child's daily care and living arrangements. This order determines where the child primarily resides and which parent will then handle the day-to-day responsibilities. So, while custody is about big decisions, care and control is about where and with whom the child will live with day to day. Who gets care and control of the child in a Singapore divorce? Here's how the court decides. Care and control refers to where the child will live after the divorce and covers responsibilities such as daily routines, schooling, meals, as well as rest times. Typically, this role is granted to mothers, especially for young children, as it's generally seen as beneficial for them to live with their mothers. But more importantly, mothers tend to get care and control of young children because they also tend to be the primary caregivers of the children at the time. However, fathers can also seek and argue for sole care and control if they can prove and demonstrate that it's in the child's best interest or if the mother also consents. In some cases, the court may grant care and control to the father after evaluating the child's needs and wishes. Ultimately, the decision rests on what best serves the child's welfare and stability. Ever heard of something called shared care and control in divorce cases? Here's how it works in Singapore. Shared care and control means a child's living arrangements alternate between both parents. This option is sometimes considered when both parents have equally fulfilled caregiving roles before the divorce, and the court then believes it will serve the child's welfare. Importantly, shared care and control isn't a 50-50 time split. It's a practical arrangement based on each family's unique circumstances. For example, the court may find it unsuitable if there are logistical issues, such as managing school supplies across homes, or if one parent's new residents lack stable caregiving support. Ultimately, shared care and control is granted only when it's clearly in the child's best interest and practical for both households.